Good morning.
Morning.
Good morning.
We're here on case number 21-1498, Gregory Bender versus the state of Florida. Thank you all for being here in a timely fashion. I have the privilege, as you can see, of sitting today with Judge Soud and Judge Boatwright. I believe in the midst of many firsts on this new court, this is the first time we have sat collectively on a Zoom OA. It is certainly the first time I've presided over a Zoom OA. I know I'm dealing with very fine and experienced counsel, and I know you have done Zoom OAs before, but for the benefit, I guess, of the appellate record, if you would just be mindful of the Zoom format. I'm certain you've turned off your phones and/or muted your phones. That would be appreciated if you would do your best, and I know this is hard, to try not to talk over others. I know judges have a tendency to ask questions at times where you really want to make the point. So if you would just be gracious enough to pause when one of us may have a question for you, that would be appreciated. I think what I need to find out from you, Mr. Ufferman, is how much time you would like for rebuttal.
5 minutes, Your Honor.
All right. Thank you, Mr. Ufferman. If there's nothing further, you may proceed.
Thank you. Good morning. May it please the court. Michael Ufferman on behalf of the appellant Greg Bender. And as I indicated, I'd like to reserve 5 minutes of my time for rebuttal. There are 4 issues raised in the briefs, and it's my intent this morning to focus on the first issue and to rely upon the briefs for the remaining issues. But of course, if the court has any questions regarding those other issues, I'm prepared to answer those questions. The first issue concerns whether or not the trial court erred by denying Mr. Bender's motion to suppress. And this issue has 2 components to it, a factual component and a legal component. I'll begin with the factual component. The victim in this case, Patrick De La Cerda, was found dead on the morning of February 27th, 2018. My client was developed as a suspect, and then later that evening, the same night, February 27th, and Patrick De La Cerda's body was found in Deltona in Volusia County. Later that evening, February 27th, law enforcement officials from both Volusia County and Orange County went to my client's residence in Windermere in Orange County to arrest my client for the misdemeanor offense of violating an injunction. And the record is undisputed that when my client was arrested, he was outside his residence. He was arrested without incident. He didn't attempt to flee inside. There was no indication that there was anyone else inside the residence. Ultimately, my client filed a motion to suppress, and he asserted that the very next day, February 28th, law enforcement officials executed a search warrant at his residence. But in the motion to suppress, he alleged that on the 27th, when he was arrested, law enforcement officials entered his residence and either did an illegal protective sweep or a sneak peek, and that tainted the subsequent search warrant affidavit and execution of the search warrant on February 28th. So there was a suppression hearing in this case that was held on May 20th, 2021. And at that suppression hearing, several officers were presented who were present on the evening of February 27th. Many of those officers said that they themselves didn't go inside the residence, and maybe they didn't recall whether or not someone in fact did go inside. But one officer in particular, Deputy Swank with Orange County, specifically said that after my client was arrested outside his residence, he and other officers went inside the residence to conduct a sweep or for security purposes. And it's that testimony that I'm relying upon to establish the factual basis that there was, in fact, an illegal entry on February 27th. Because
Mr. Ufferman, I'm sorry to interrupt you. Was there any competent substantial evidence to the contrary?
No. And the reason for that is this. The other officers either said they didn't recall or didn't remember, and particularly the state in their answer brief relies upon the testimony of Detective Rambo and Sergeant Strickland. But as I've cited in the reply brief, if you look at the pages the state relies upon, if you look at the suppression hearing transcript, when both of them were asked, did anyone enter the residence on the night of the 27th, their answers were along the lines of, I do not recall. I don't think so. I don't believe so. And I've cited.
So your contention is that their testimony was somewhat equivocal.
Well, I guess I'm relying upon the Fox case from the First District Court of Appeal. And in Fox, and I'm quoting, this is page 418 of the opinion, a witness's testimony that he or she does not remember an incident does not constitute competent substantial evidence that the incident did not occur. So,
and I appreciate that principle of law. On page 1341 of the record, which I think is Strickland's testimony, it says, and I think this was referenced by the state in its answer brief, after that, and I'm reading on page 1341 in its line, beginning at line 22 of that particular, or I'm sorry, 18 of that particular page. After that, did you direct Mr. Ventriere or Mr. Swank and the other people that were with you to clear the house for occupants? Answer, I did not. So if any of the other deputies that were there said that you directed them to do that and that they followed that order, that they would not be telling the truth. And then the next page, which is 1342, answer, well, I'm telling you, I don't recall us searching that house. I don't recall going into that house at all. Question, I didn't use the word search, so I just asked if you directed them to clear the house. And the answer was, we did not. We did not. As far as I know, we did not clear that house. I do not recall clearing that house in any way, shape, or form. Is that not competent substantial evidence to counter Swank?
no, Your Honor. And again, I submit that's the exact language that the First District was referring to in Fox. Simply saying, I don't recall, I don't remember, is not specific to say, no, that definitely did not occur. But when you compare it to Deputy Swank, he specifically said, did you go inside? Yes, we did. Not, I believe we did. I recall we did. He was specific. Yes, me and other officers went inside that house. And again, I don't see how you can square what was being said there on pages 1341 and 1342 with the language from Fox. If I don't recall is not enough to assert that that principle did not occur. And Swank specifically said that it did. And the other point that I would make is the trial court really wasn't clear about what Swank said. The trial court seemed to indicate after the testimony was presented that no one had said that they went inside. Defense counsel asserted that, Your Honor, if you remember Deputy Swank's testimony, in fact, maybe we can play back Deputy Swank's testimony. The court couldn't arrange for that for whatever reason. And obviously the prosecutor agreed that Deputy Swank had in fact said that officers went inside. But defense counsel interjected and said, are you finding Deputy Swank is not credible? And the trial court specifically said, I am not making that finding. Now, if the trial court had made a finding, I don't think Deputy Swank is a credible witness, I'd be in a much different position. Obviously, the trial court, as the finder of fact, has the right to make those findings, and this court must defer to those factual findings. But that's not what's in this record. So we have Deputy Swank's uncontradicted testimony as far as what he specifically remembers, and we have the other deputies, Strickland and Rambo, simply saying they do not recall that occurring. And pursuant to Fox, I submit the only way that you can look at this record is a conclusion that the trial court's conclusion that there was no entry on the 27th is not supported by CSE, or only CSE in this record is Deputy Swank's testimony.
Is Deputy Swank's testimony that he only entered just inside the door? I think he may have referred to it as a living room. If he just went inside the door and did not search other rooms beyond the threshold of the door, is that relevant to the analysis of your argument?
It is, but I think he said other officers went inside. He indicated where he went, I think, but the idea was he was saying they went in for security purposes. I think the reasonable conclusion from that is they were clearing the house to make sure no one else was there. That's the reason they went inside.
Okay.
So let me turn to the legal premise that applies after establishing that this record indicates that there was in fact an illegal entry on the 27th. And of course, that's the murder.
Mr.
Yes,
Upperman, is there anything in the affidavit of the search warrant that references this protective suite?
No, but and you know, the state makes that.
So let me just stop. Well, let me ask you one more question. Then why wouldn't the independent source doctrine apply?
So obviously the independent source doctrine comes from the Murray case. And to answer your question, Your Honor, to go back to that, I don't think we would expect that they would indicate that. And in fact, in Murray, that also wasn't indicated. Murray involved the warehouse. They initially, law enforcement officials went into the warehouse illegally, and then they later went back with a warrant. And Justice Scalia, in the majority opinion in Murray, specifically says, the district court found that the agents did not reveal their warrantless entry to the magistrate, and they did not include in their application for a warrant any recitation of their observations in the warehouse. That's true here. The trial court, I think, basically made two findings. That was one of them. I think the Supreme Court said that's not dispositive. And if anything, it's common sense. If they went in illegally, if they did a sneak peek, you wouldn't expect them. I hope that they would. I hope all officers are honest. But if they're trying to cover up something that they did illegally, you wouldn't expect them to acknowledge in the search warrant affidavit that they went in illegally. And you wouldn't expect them to cite the things that they saw when they went in illegally. That's not the question to be asked by Murray. Pursuant to Murray, the state has the burden to prove by clear and convincing evidence that the ultimate search warrant affidavit and execution of the search in this case was not prompted by what they had seen on the 27th. And I submit the state cannot meet its burden in this case. A couple of points I want to make about that. One is I'm confused, and perhaps Ms. Davenport can clear up the confusion. I'm not sure I understand it, but the state cites in their answer brief to this idea that the person that drafted the narrative for the affidavit wasn't even present on the 27th. Now, there is support for the state saying that because they cited to the testimony from the suppression hearing from a Sergeant Amrine, and Amrine says that he's the one that drafted the narrative. But when you look at the affidavit itself, and this appears on page 314 of the record, the affidavit, the appiant for the affidavit is Detective Rambo. And I know the court picked up on this, but let me just say it to clarify. Rambo is spelled two different ways in the record, R-A-M-B-O and R-A-M-B-E-A-U. It's obviously the same person. They're both William Rambo with Volusia County. But it's Detective Rambo, who is clearly present at the time of the entry on the 27th. It's the affiant for the search warrant affidavit. I think one of the key indicators, and perhaps the best example of why the search that occurred and the affidavit for that search on the 28th was prompted by what they had seen on the 27th is also page 314 of the record. It's 4 paragraphs up from the end of the affidavit. And they're referring to my client's ex-wife. They interviewed her. And they say, Damara confirmed Gregory owned several firearms to include handguns and long guns. The guns are located throughout the house and in a secured gun safe. If you review the ex-wife's recorded statement, and it's contained on page 1021 of the record, it begins there. At no time does the ex-wife say that guns are located throughout the house. She's very specific about where she had seen the guns. Now, she had seen them a couple months earlier. She hadn't been in the house since at least December, but she says the guns were located in my client's closet in a safe. And she also indicates one other gun may have been behind the bed, but she does not say throughout the house. By comparison, if you look at the photographs, and the photographs, they weren't initially part of the record, we supplemented the record with them, and I cited in my reply brief, I cited to all the different pages that the guns, ammunition, paraphernalia throughout the house. Several rooms in the house contain all of this evidence, ammunition, gun evidence. That's very consistent with what they would have seen when they went in on the 27th illegally and conducted their sneak peek to show that the guns were located throughout the house. Again, where else would they have gotten that from? They didn't get it from the ex-wife. She didn't say that in their statement. It's clearly what they observed when they went in there illegally on the 27th. Another point I'll make about that is I don't think the trial court in this case answered the question that's required to be answered by Murray. The trial court wasn't necessarily clear about whether or not there was an entry, but she said if there was an entry, kind of going back to your question, Judge Jay, she said nothing about their entry was indicated or listed in the affidavit. Again, that's the same as in Murray. You wouldn't expect them to put that in because they're seemingly trying to cover up their illegal entry. But the question that must be answered is, would they have applied for the search warrant affidavit without observing what they saw when they illegally went in on the 27th? In Murray, that's the question that was not answered by the district court, and ultimately the U.S. Supreme Court sent it back for that question to be answered. In this case, the judge did not make a finding that the independent source doctrine applies because they would have applied for a search warrant regardless of the illegal entry. That's not at all what her findings were. She made 2 different findings in this case. One is on 1445. There's been no information or evidence presented to this court that anything from that search on the 27th was included in the affidavit. We just discussed that. And she also says, I understand this is your argument, but the Volusia County officers indicated that they had their own independent investigation. And that's why, based on that information set forth in their search warrant, and that's on page 1447, 1448, she does not answer the key question in this case. And I submit it's because the state has not met their burden of proving by clear and convincing evidence that what they saw didn't prompt them to ultimately seek the affidavit and then the warrant. And again, because that question has not been answered, there's no way that I believe this court can make the final conclusion that independent source does apply to this case.
Is not, excuse me for coughing, is not the statement set forth in the affidavit for search warrant relevant? The statements of an ex-girlfriend, the statements of an ex-wife, the statement of the victim's father, the nature of the victim's unsuccessful effort to obtain an injunction against the defendant in this particular case. Aren't the individuals set forth and the substance of those statements sufficient in and of themselves to establish an independent source and a basis to obtain the search warrant?
There may have been evidence for an independent source, but I don't think that's the question that needs to be asked pursuant to Justice Scalia's opinion in Murray. The question that must be asked is, can the government prove by clear and convincing evidence that they weren't prompted to ultimately obtain the search warrant affidavit based on what they observed during the illegal entry? And I submit, again, when you look at what they specifically said in the affidavit about guns supposedly being throughout the house, and we know that's what they would have seen when they went on the 27th, but that's not what the ex-wife said. It was that observation on the 27th with the guns and ammunition and other gun paraphernalia everywhere in the house that prompted them ultimately to submit this affidavit and get that search warrant. Is there independent source evidence there as well? I have to concede there is. Of course there is. They put that in the affidavit, but that's not the question to be asked by Murray. Murray specifically says, the ultimate question, therefore, is whether the search pursuant to the warrant was in fact a genuinely independent source of the information and tangible evidence at issue here. This would not have been the case if the agent's decision to seek the warrant was prompted by what they had seen during the initial entry. That's the question. If they were prompted to ultimately go get that affidavit, because they acknowledged, they arrested my client, they tried to question him, he declined to make any comments. At that point, the suppression hearing testimony establishes that they did not have probable cause to search the residence, but yet they went into that residence, they knew this was a shooting, and they saw firearms everywhere in that house when they illegally entered, and that's what prompted them to ultimately seek this search warrant and execute it on the 28th. And we know that again from this statement that guns are located throughout the house. Where else would they have gotten that information? There's no other way they could have gotten that other than what they saw when they went in, as the pictures demonstrate. That's not what the ex-wife said, and that's what prompted them to ultimately get the affidavit or submit the affidavit and get the warrant in this case. And for all those reasons, I submit that the trial court either didn't make the proper findings under Murray, or the state failed to meet its burden by clear and convincing evidence that they weren't prompted by what they saw based on the illegal entry on the 27th. And I'd ask this court to reverse. I'll reserve the rest of my time for rebuttal.
Thank you, Mr. Ufferman. Ms. Davenport?
May it please the court. My name is Chris Davenport, and I represent the state of Florida. Let me start by clearing up the purported confusion noted in footnote 9 of the reply brief and brought up by Mr. Ufferman as to Detective Rambo and who was there as far as the affiance for the search warrant. Detective Rambo was the only Orange County, he was in charge of the Orange County investigation, and that's where the search took place. So they needed an Orange County officer to submit the warrant because it was going to be an Orange County search. He testified at the suppression hearing that the probable cause for the search, he had no personal knowledge of. It came from Detective Weaver. Detective Weaver testified, yeah, it was my investigation. I was the case agent, and Sergeant Amron was the person who provided, who typed up the affidavit itself. So that's why they both testified. We weren't even at the house on the 27th. When we went to serve the warrant was the first time we had been there. And that's why the actual information in the warrant came from people who weren't even there on the 27th. Yes, Detective Rambo signed it, administratively, but he did that under the fellow officer rule. He relied on Detective Weaver's narration of how that worked. So just to clear that up, let me say that the trial court's specific finding that there was no protective search is fully supported by the record, and that ends the inquiry right there. If there was no search, there's no taint to be dissipated. 6 officers went to arrest this defendant for a misdemeanor violation of an injunction. One of the officers, the patrol officer, DeLeon, said she did not remember going in the house or not. She had no memory of that. Doesn't remember going in. 3 of the officers from the night investigation team testified that they did not go in. They specifically said, I did not go in. And that was Venturi, Strickland, and Stefans. All said, I didn't go in that house. Detective Rambo said he had no memory of going in, does not believe that Sergeant Strickland told them to go in. It wouldn't have been appropriate because there was no reason to go in. And then, so the only testimony that they went in the house was Officer Swank. And he said he went in there because Strickland told him to. And Strickland specifically testified, I did not give that order. I didn't tell him to. And again, everybody agreed there was no reason to go in there. So the trial court, while not wanting to make a specific finding on the record that this deputy was not credible, clearly believed Mr. Strickland and did not believe Swank when he said there was no search. So it's up to the trial court to make that credibility determination. And he did that here. He doesn't have to call the deputy incredible for that to be a valid factual finding. Even if Mr. Swank did go in the house, he said he went in there for 2 minutes and he stood at the door. Now, he said other officers were in there. He didn't identify them. He said they were in there for minutes. So even if he went in there and believed other officers were in there, he didn't testify to any observations in there. He didn't say, yeah, I came out and told the officers in Volusia County that there were a bunch of guns in there. None of that is on the record. So there's no record support for any observations that could have tainted the warrant. What the record does show is that they sent 6 officers to arrest this guy for a misdemeanor injunction because they believed he was a murder suspect and they didn't want to have any trouble. That's why they sent so many officers. They knew right up front he was a suspect in the murder when they went to that house. This isn't something that, oh, we were just arresting him for an injunction and then we saw a bunch of stuff in the house, so we decided to search his house. That wasn't what generated the decision to go search his house. That was generated by the interviews they did that day with the victim's girlfriend, with the victim's father, who said he received a call from a number he did not know who it was, but it sure sounded like the defendant's voice to him. Both of these witnesses that were interviewed independently by the Volusia County officers said that the defendant had threatened the victim. The victim was afraid of him. The girlfriend said that she had text messages with threats on him that she had saved. So he was clearly a suspect. The day after they had arrested the defendant, his ex-wife came and talked to the case agent, Detective Weaver, and said, look, he's got guns in his house and I was looking at his stuff and he has a notebook threatening the defendant with a plan to murder him. Now, he said that was just a fantasy when I confronted him, but there's a notebook in his house with the murder plan. So once they heard that, they had probable cause to go in there. Did they know he had guns? Yeah, they knew he had guns from the ex-wife and from the girlfriend. There was no question that he had a bunch of guns and the victims had been killed by gunshot. So all of this was independent evidence. The Supreme Court has made it clear that the state shouldn't be put in a worse position if they do something wrong, that there is a societal interest in making sure that juries have all the relevant evidence of a crime. And while there's also an interest in prohibiting the police from doing something wrong, that doesn't mean that they can never get evidence once they make a mistake. So in this case, the trial court found that they didn't do anything wrong. That finding is fully supported by evidence in the record. Even if they did, the independent source doctrine clearly applies here because they did their own independent investigation. They didn't decide to search the defendant's house because of something they saw in this purported sweep. He was a suspect already. They interviewed some really damaging witnesses, and that's when they had probable cause to go search his house. It had nothing to do with anything someone saw. If the court has no questions, we would ask you to affirm. Thank you.
Thank you, Ms. Davenport. Mr. Efferman, rebuttal?
Thank you, Your Honor. May it please the court. I respectfully disagree with my colleague across the aisle regarding what the facts are and what Deputy Swank's testimony was. Deputy Swank was crystal clear that they went in the house. And then he's asked, and this is on page 1317, did you enter the house with some other night investigation squad deputies to clear the house? Answer, yes, sir. He didn't say, I believe so. I think I recall that. He is unequivocal, yes, sir. Now, he is later asked, who was the one to direct you to go in? For that, he does say, I can't recall exactly. I believe it was Sergeant Strickland. So Ms. Davenport wants to say, oh, look, Strickland said, I don't recall ordering anyone to go in the house, and that must refute Deputy Swank's testimony. Deputy Swank wasn't clear on who directed the officers to go inside, but he's crystal clear on that they did go inside, he and other officers. She says, Ms. Davenport says there's no evidence that would support that they would have seen any guns when they went inside. The evidence is the pictures. That this house was undisturbed from the moment my client was arrested on the 27th to when they conducted the search warrant and executed it on the 28th. And the pictures from the execution of the search warrant show that the guns are everywhere in plain view. If anyone who would have gone in that house, and it doesn't take many minutes to go into each room to secure the house to make sure no one else is there. So if they are going room to room, which is exactly why they would be going inside, that's what Deputy Swank said, to secure the house to make sure no one else is there. When they did that, they would have observed all of these firearms. The pictures established that. There can be no dispute about that. And again, if you look at the affidavit itself, they claim that the ex-wife said that there are guns located throughout the house. Ex-wife didn't say that. They saw that. They saw that when they went in illegally on the 27th. That's the only way. And Ms. Davenport doesn't respond to that or have an explanation for why in this affidavit they're saying that there's guns throughout the house, but yet the ex-wife didn't specifically say that. That demonstrates this was prompted by what they'd observed when they went in illegally. So when you step back from this, again, why would Deputy Swank come forward and say we went inside that house if it's not true? He has no motive to say anything other than the truth. Unfortunately, the other officers, in particular the Volusia County officers, if they went in illegally to get the sneak peek, as Justice Scalia refers to it in the Murray decision, that is improper. But he fortunately came forward and told the truth that they did in fact go inside. When they went inside, we know what they would have seen, and we know that that prompted them to put in the affidavit that there's guns throughout the house. That's why we need to go search it. And ultimately, the court, in this case, the trial court, didn't answer the question that's required by Murray. Again, the U.S. Supreme Court remanded for this question to be answered. The state has to prove that they would have been obtaining or seeking this warrant independent of anything that they observed illegally on the 27th. The judge in this case did not make that finding. Therefore, I submit that at the very least, this should be sent back for further consideration on that particular question, the same thing that was done in Murray. Otherwise, alternatively, this case should be reversed because the state failed to meet its burden of proving by clear and convincing evidence that what they saw illegally on the 27th didn't prompt them to ultimately get that affidavit and search the house on the 28th. And then just briefly, it hasn't been argued today, but the state argues this would be harmless error. Clearly, having experts testify about things that were actually taken from that house is far different from having the ex-wife's testimony about what she thinks she remembers in a notebook. The error could not be harmless. The state could not meet its burden of proving beyond a reasonable doubt that the evidence that was seized and introduced during the trial didn't impact the outcome of this trial. So for all those reasons, I'd ask this court to reverse. Thank you.
Thank you, Mr. Efferman. Thank you, Ms. Davenport. It was well presented on both sides. We are now in recess.